Welcome everyone. Welcome to my YouTube channel Judiciary 009. In this video, I will cover two acts: Delhi Special Police Establishment Act and the Central Vigilance Commission Act. These two acts are very complementary and playing a complementary role. Along with these laws, I will cover all judgments with regard to both the cases, both the acts. I will cover also the type of authority covered under these two acts and the procedure of inquiry and investigation. And there is a complex procedure given under section 8 clause 1 clause C and 8 clause 1 clause D along with section 17 and section 8A and 8B be read along with section 11A. These are the important sections which has to be understand what is the procedure of inquiry and investigation. Before starting with these acts, we have to firstly done the authorities, the type of authorities under in both the two acts. There are 5 type of authorities. I have make a comparison of that authorities which will be a easiest way to understand this. First is a director ED. Director ED is governed under section 25 of CV Act. If we consider CV Act, there are two authorities under CV Act: section 4 CV Act and section 25 CV Act. That are the two authorities. Section 4 CV Act says that there shall be a CVC and VC, and section 25 says there shall be a director ED or deputy director ED. Both appointment are not made by the single person. That director ED is appointed by a central government. CVC and VC is appointed by the president. Both the based upon the committees. So whenever CVC has to be read, always read section 25 and 4 with regard to the authority, and there is always a committee. If you consider a ED director under section 25 of CVC Act, appointment is made by central government, but there is a committee having a CVC, VC, secretary of Minister of Home Affairs, secretary in charge of Minister of Personnel, and secretary Department of Revenue. There are 3 secretaries and 2 other authorities. One is CVC and VC, and that person must be additional secretary or above level, having a integrity and experience, and that too 2-year minimum 2-year term has to be there of that authority, which may be extended for 1 year each and till 5 years. That is due to latest amendment 2021. It is also in a case of section 4 CVC Act that president appointed by CVC and VC, and that is through by committee. Committee is where Prime Minister is a chairperson, Minister of Home Affairs is a member, and Leader of Opposition is also a member, and their terms are 4 year or 65 year, whichever is the earlier given under section 3 subclause 3 of CV Act. So there are director of prosecution of CBI and CBI director. These are the two authorities covered under DSPE, Delhi Special Police Establishment Act. That 2 appointments are made by central government, but in CVC, one is appointed by central government ED, and CVC and VC is appointed by the president. There are section 4BA provide prosecution, and director CBI is appointed under section 4A. Whenever a director of prosecution, when they need a prosecutor, a prosecution department, director of prosecution, CVC is the committee. CVC can recommend that it is a fit person to become a prosecution from a director of prosecution. But in case of CBI director, there must be a committee of PM, Leader of Opposition, Chief Justice of India, or Judge of Supreme Court nominated by CGI, nominated by CGI. That is also having a same term like 2 year and 1 year extension is to be given after 2 years and till 5 year, and that person must be of IPS level, and seniority and integrity and experience has to be taken care of. And in case of corruption cases, generally we have seen the CBI is investigating agency, the prosecution is conducting the prosecution on behalf of that. And section 4b is also latestly in 2021 was amended. It says that in the cases of public interest, on a recommendation of the committee, 1 year extension may be given each year and till 5 year from the date of appointment. That can be happened. So two authorities, ED and CBI director, both must be till 2 year. At least 2 year must be at their seat. They can be extended 1 year by 1 year and 1 year till 5 year. That is because of our latest amendment 2021, which is made under CVC Act under section 25 and section 4b of DSPE. That are the three sections. That are the type of authority. There is one other authority that authorities are four in number, 1, 2, 3, 4, and fifth authority is given under 4C. That is a superintendent of police and above level, that is given under DSPE. That is appointment is always made by central government. So whenever the authority is to be mentioned under DSPE, always appointed by the central government, always by one committee, and that committee, there are three committees, there are three appointments under DSPE. One is director prosecution, other is director of CBI, and third one is SP and above level person. If you are considering that director of prosecution, the committee is a CVC. CVC will take a decision. But in case of director CBI, PM, leader of opposition CJI, and judge of Supreme Court nominated by CJI are the recommending authority committee. In case of SP and above level, appointed by the central government, recommended by the committee, CVC, VC, Secretary Home Ministry, Secretary of Department of Personnel, that are the four members. These are four members. These are three members. These are one member. 1, 3, and 4 members are given under DSP committees. So there is one judgment which says which upheld 2021 amendment, that is Jaya Thakur versus Union of India. It upheld section 25 of CVC Act in where ED appointment is there, and it also upheld section 4b of DSPE Act wherein a CBI director extension is to be given. Then extension shall be given in rare and exceptional cases. It is not a regular. That was one case, Common Cause versus Union of India 2021 Supreme Court. There is one other case, appointment of CVC by selection committee is open for a judicial review, which says the selection of a CVC must be open for a judicial review. Center for PIL and others versus Union of India and others. There is one other case, CVC does not have a legal power to grant sanction. So CVC is only advisory body. CVC does not grant a sanction to have that person to be prosecuted. Jan Krishnan versus CVC is the case. CVC role is to tender advice to central government. It is not a sanctioning authority. There must be a competent authority who will provide the sanction. That is also the case Vijay Rajmohan versus CBI 2022 Supreme Court. Thereafter, one case is N. Kananda Dasan versus Ajay Khose 2009 Supreme Court. In this case, Supreme Court held that the eligibility given under section 3 of CVC for candidature of a Central Vigilance Commission must be without blemish. and mere eligibility does not entitle an appointment if integrity is questionable. So in this case, Supreme Court said, even though you are eligible, being a CVC, but if you have a your integrity is if your integrity is questionable, then your appointment may not be made even though you are qualified otherwise. Then there is a vigilance awareness week also. It is annually we are celebrated on the basis of Sardar Vallabhbhai Patel's birthday on 31st of October. In this year it was celebrated on October 27 to November 2 2025, and there was an annual campaign by the CVC to promote integrity, transparency, accountability in public life. And in this year the theme was vigilance over our shared responsibility, vigilance over shared responsibility. Then there is a one case, Advance Insurance Company versus Gurdas Mal 1970 Supreme Court, in which Supreme Court declared DSPE as a constitutional law. And AKK Nambiar versus Union of India 1969 Supreme Court, it is also said that DSPE is a constitutional law. Then there is one case, K Chandrasekhar versus State of Kerala. In this case, Supreme Court said that if state give a consent under section 6 of DSPE, that the investigation or the FIR may be registered against that particular officials of that state government if with regard to the corruption. And during investigation is ongoing. Now the concerned state cannot unilaterally withdraw it that consent under section 6. If the investigation is ongoing against that official, now the concerned state government cannot withdraw unilaterally that that consent. Then there is a case Navinder Kumar versus Union of India and others. That is a two-judge bench decision of 2013 Guwahati High Court. In this case, Guwahati High Court declared the CBI as an unconstitutional body, and the name of that judge was who delivered that judgment, I.A. Ansari Indra Shah. In which in this case the central government is proposing a union list that in the 7th schedule of Indian Constitution they have a union list, entry 8 and entry 80, under which entry 8 says that the central government make any agency for investigation, and entry 80 says that they have it permit the union to extend police to a state within the sphere of state. That was the objection made by the central government, that they have authority to make a CBI for the purpose of investigation. But the Guwahati High Court does not upheld that they have a power under entry 8 and entry 80. Later on, there are lot of cases pending against many official, which was conducted by the CBI, like 2G case, coil scam case were also going on. When this judgment came, all the said accused person came to the Delhi High Court, came to the different high courts, so as to stop that investigation, because the investigation agency itself is declared unconstitutional in this case, and that will result into chaos in whole India. And that is why that central government came before the house of CGI at night, and Chief Justice of India stayed at judgment, and still that judgment is stayed. On April 1963, special police under DSPE called as a CBI by resolution, and first director of CBI is D.P. Kohli. Thereafter, two cases, Vaneet Narayan versus Union of India and Manohar Lal Sharma versus the Principal Secretary and other. In this case, the Supreme Court says that the CBI is a parrot in a cage, or CBI is a caged parrot. By the investigation agency is not doing things in a in the way it was to be expected from them. That is why the Honorable Supreme Court made this observation. One is CBI versus State of Rajasthan. In this case, Honorable Supreme Court said that magistrate does not have a power under Section 156 Clause 3 to authorize to give direction to CBI for investigation. They cannot, magistrate cannot give a direction to the center or state government to investigate the case from CBI. There is one case, CBI, State of West Bengal and other versus the Committee for Protection of Democratic Rights, West Bengal and others. In this case, Supreme Court said that Supreme Court has a power under Article 32, High Court has a power under Article 226. They can direct investigation to be conducted by CBI in the states. No need of a consent from said state is necessary. Section 6 says there may not be no FIR, no investigation if consent of concerned state government is not taken. So if CBI want to investigate the case in the state, they need a consent from that state government under Section 6. So if there is no consent, no FIR can be lodged by the CBI, no investigation can be conducted by the CBI. That is a case M. Balakrishnan Reddy versus Director CBI 2008 Supreme Court. Thereafter, one case for Fertico Marketing Investigation Private Limited versus CBI 2020. In this case, Supreme Court said that Section 5 is a federal character of a constitution, federal character of the constitution, because the central government extend order of investigation through CBI. Central government have a power under Section 5 to extend the investigation through CBI in the railway area in the state, but that state is subject to Section 6. It means if the central government want to investigate any matter from CBI in the state government, then they have to taken care of that consent from that state government under Section 6. Then there is a case Subramaniam Swamy versus CBI, in which case Section 6A subclause 1 and Section 26 subclause C of CVC and Section 6A subclause A1 of DSPE Act declare unconstitutional. This judgment, thereafter one case also came, CBI versus Dr. K.K. Kishore 2023 Supreme Court. In this case, Supreme Court said the judgment of Subramaniam Swamy versus CBI is having a retrospective effect. Then there is one case, CBI versus Anup Maji. It is very important case. In this case, Supreme Court said that CBI can investigate against employees of a railway even when they are posted in any state. Then there is a case Alok Kumar Verma versus Union of India 2019 Supreme Court. In this case, Supreme Court said that the CVC cannot divest a CBI director of their powers without approval of a high-powered selection committee. So whenever you want to divest the power of a CBI director, you being a CVC want to divest the power of a CBI director, then you need a approval of a high-powered selection committee. The committee which is selected the CBI director has to taken the having a power of such approval. Thereafter, Section 8. Come into the Section 8 now. Section 8 subclause 1 subclause A said that it is having a superintendence power of a CBI in the cases of corruption. CVC having a superintendent power over CBI in the cases of corruption. So other cases under CBI Act which says that superintending power over CBI is to be given to the central government if in other cases. But in cases of corruption cases, the superintendent power is given to CVC. And clause 1B, direction may be given to the CBI by CVC to discharge of function. Then section 8 clause 1 clause C. If let's suppose central government made reference to CVC, central government receive a complaint of a corruption against any public servant, or they knew that that public servant is making a corruption, and that central government take a decision, why not take a proceeding, initiate proceeding against that public servant? They made a reference to CVC. They have to give a reference to the CVC. And now CVC having a three options. CVC can inquire himself, or they can make inquiry from other agency, or they can also order investigation. If they can inquire himself, then a report must be given to the central government under section 17 with advice to central government and plus that department where that officer is appointed. And that report may be agreed by the government or may not be agreed by the government. If not agreed by the government, then communication to CVC must be made by the government. That is section 17 clause 3 proviso is then communication back to CVC that we are not taking any action. We are not agree with your investigation. The word shall consider is mentioned there. So CVC, the report of CVC always taken care of by government, but government is not bound as per the proviso. So whenever inquiry make himself, report to the central government. If inquiry through vigilance officer, any authority or including vigilance officer of a concerned department, let's suppose the officer is from prosecution department, complaint is to the central government, and that state government has already been given a consent to the for CBI investigation, etc. Now, even though the investigation, this is not investigation, this is only inquiry. In this case, inquiry. There is no need of any consent from that concerned government, but the officer must be of central government. That is all. Inquiry by that vigilance officer of that department where that person is appointed. And whenever the inquiry is conducted by that officer or other authority, the report must be given to CVC. And that report then referred to the central government or the concerned department along with advice to the them. In case of investigation, if CVC recommended the investigation, it may be investigate through CBI or some vigilance officer like DSP vigilance, SP vigilance, ACP vigilance. And that case, after investigation, that agency, the report must be given to CVC. Then section 8B comes into play. It says, now CVC official can file a charge sheet, or CVC official may recommend a departmental action against that person. And that investigation has to be completed within 6 months. If they need a more time, after 6 months, then they have to file before CVC. Then we need a time. Then CVC can further give a 6 months. So investigation report, even though it is a charge sheet by CBI, they have to file before CVC. The officials of CVC will taken care whether to file that charge sheet before a special court or not. Even they can file a departmental proceeding. They can initiate the departmental proceeding by giving that report to that concerned department. Generally, in every case, whenever the investigation is completed, the charge sheet has to be given to CVC. The officials of CVC must file that charge sheet before a special court, and a departmental action also be taken by giving that report to the concerned department of that official. And that is how the section 8 clause 1C, C is a central government. It means a reference from the central government. We have a 3 option to CVC. First is inquiry, second is inquiry from other person, the third is investigation. Investigation, they can having two agencies from them, they can investigate. Inquiry can be conducted through vigilance officer or through other authority. Inquiry can be himself. Always all reports back to CVC, and CVC can refer that report to the concerned central government or concerned department for all the advice. And section 17 come into play. Central government may agree, may not be agree, and communication to CVC if not agree. Section 8 clause 1 clause D says whenever the complaint to CVC, exactly corruption complaint directly came at CVC office and against a specified officer given under section 8.2, it says that it is a complaint against group A officer of a central government, or reference made by the Lokpal under section 20 clause 1 2010 Lokpal and Lokayukt Act. So if complaint can be filed before a Lokayukt against group A, group B, group C, group D officers, and Lokpal having authority under section 20, that they, if it is a corruption case, they can refer that complaint to the CVC under section 8A. Reference any officer, basically A, B, C, D, any officer. But if you consider this clause, section 8 clause 1 clause D, in this case they already got the complaint under section this against group A, and reference through B, C, D, or such officials which are central government notified that in these officials the Lokpal Lokayukt having a power to get a complaint and refer the same to the CVC. Or the CVC got a complaint from against that government officer who are notified by the central government. Central government notified that officer that if any complaint of a corruption is made against that person, that may be made to CVC, and CVC take action against them. If no notification of that officer, then all the officer will come under the preview of that case. So if the preliminary inquiry under section 8A, that inquiry when Lokpal refer the case against that authorities under section 20 of Lokpal Act, and that is a group B, C, D, generally B, C, D. So A, they have already got a receive a complaint, but you can also file a complaint against that authority to the Lokpal. Lokpal also having an investigation power, Lokpal also having a preliminary inquiry power, but generally in the cases of corruption they refer that to the CVC, and CVC preliminary inquiry has to be conducted under section 8A within 90 days, and further 90 days may be given to him, extended by CVC. And CVC after preliminary investigation may ask the CBI to investigate the matter or disciplinary action to the competent authority against that official. Thereafter section 11A, when case referred through Lokpal under section 20 clause A, 20 clause 1 under Lokpal Act, then preliminary inquiry by director of inquiry under section 11A is always, and director of inquiry is a joint secretary or above level person. That is all about this whole 2 act. You can revise this again and again to so as to understand this the whole concept, the procedure of inquiry and the procedure of investigation. That is the way you can know all the sections. Thereafter you can understand section 13 itself, 13 13. तेरा भाईचारा नहीं पैसा लगेगा, तेरा भाईचारा नहीं पैसा चलेगा. That is section 13 is says that expenses of commission to be charged on a consolidated fund of India. Consolidated fund of India. Section 13 says saying so. So all other sections are very smaller in number. You can easily grab that. I have covered all the judgments and I have covered the procedure of inquiry and the procedure of investigation. That is all about these two acts. Thank you so much.